Welcome to the City Futures Research Center Seminar Series. I would like to acknowledge that we are meeting today on the traditional lands of the Aboriginal people of the Eora Nation, and I'd like to pay my respect to the elders past and present, as well as any First Nations people joining us today. If you're joining online, please mute your microphones and turn off your cameras during the presentation. Once we get to Q&A, we are welcome to turn your cameras back on and unmute yourself. You can also put your questions into the chat box, and I will be monitoring for the chat box for questions. Now I'd like to hand it over to Professor Hazel Easthope, who will introduce today's speaker.
Everyone, I am very pleased to introduce today Professor Doug Harris. Doug is Chair in Legal History at the University of British Columbia Peter A. Allard School of Law. He's also one of the world's leading, in my opinion, this is not his own words, researcher on condominium property law. He's the man to follow for all the new ideas. And today he's going to share some of those with us in his paper on legal architectures of property and the city. So welcome, Doug.
Hazel, thank you very much. It's a great pleasure to join you from Vancouver, from the University of British Columbia, and from the traditional, ancestral, and unceded territory of the Hunkaminam-speaking Musqueam people. The Musqueam will feature later on in this talk. They're not only the traditional caretakers of the territory, but are very active participants using contemporary property forms in the building of the modern city. So I'll come back to them towards the end. It's a great pleasure to be here at the City Futures Research Institute. It's the center. It's a center I've long admired for its work, and I know the work of many of you, Simon and Bill, and of course Sophie May-Kerr and Laura Cremellin and Hazel Easthope. The three of them collaborated when we hosted the multi-owned property research forum in Vancouver a couple of years ago. So it's a great pleasure to be at the center. And thank you, Georgia, for looking after the logistical arrangements. I want to talk today about architectures of property in the city, or legal architectures of property in the city. And I use architectures cautiously and somewhat generally, in the sense that I suspect there may be some architects or those who spend a lot of time with the physical built form. I'm using it more loosely to describe structures and forms, and legal structures and forms that participate, that are part of creating the built environment in the city. And I'm particularly interested in property forms and the way in which forms of property construct the spaces that we move through, the built environment that we move through. But I'm also interested not just in the city as the stage or a passive player on which property unfolds, but in the presentation, I want to think through the ways in which the city is also a participant in creating the legal forms that then are used in the city to produce and reproduce the city. So it's thinking through cities as sites of property law and the way in which they both construct and are constructed by forms of property. And there's three forms in particular that I intend to pay attention to, if I can get the clicker pointing in the right direction here to close down. Seem to have lost contact with the, there we go, okay, good. So there's three forms that I want to pay particular attention to today. The first, condominium. And I'll maybe spend the least time, it's the one I've written most about, condominium or strata property, strata title as it's known here. Then airspace parcels. And finally, the use of leasehold, long-term leasehold interests within strata. So those are the three legal architectures, or the three forms of property that I want to pay particular attention to today. And I do so in the city of Vancouver. And then here's a sort of a poster image of the city of Vancouver, an image of the city of Vancouver as one of the poster cities for urban redevelopment in the last half century. It's a city not without many problems, but also a city in which these legal forms, the condominium, the airspace parcel, and the leasehold condominium are becoming increasingly prominent. And my argument is that's an architecture that, as much as the steel and glass and the architect's designs, is responsible for this space. I'm also interested, and we'll talk primarily about Vancouver. It's my home city. It's a city that there are a lot of comparisons to with this city, Sydney. David Lay features Sydney and Vancouver as one of his gateway cities in his Housing Booms and Gateway Cities recent book, right? One of the cities that acts as the interface between local, national, and international flows of capital and housing. So there's lots of similarities. There's important differences between these cities. Sydney is at least twice the population of Vancouver. But I also know that a number of you know a good deal about Vancouver, doing comparative research projects between the two. Okay, so enough by way of introduction. Let's jump in and speak about condominium. But before we get to condominium, this tower, the Ocean Towers, was built in the late 1950s on English Bay, right on the waterfront, on the edge of a neighborhood called the West End. It was built using the cooperative form. So the cooperative, unlike the condominium, has a single owner of the freehold. The condominium or the cooperative association holds the freehold interest, and then owners of units in this building hold shares in the cooperative form, and those shares entitle them to a lease to the unit. So before the property strata title or condominium form was available, one could create a mix of private and common interests within a building.
Yeah. Huh. Just started late.
Using other forms, including including the cooperative form. Problems with the cooperative. So if you were trying to finance the building or finance the purchase of a unit within a cooperative, there was only one property interest, the freehold interest held by the cooperative association. And if a lender wanted to take a property interest as security for a loan, then it was the cooperative association that had to transfer the mortgage. And then each of the owners, as members of the cooperative association, would be responsible for that collective charge against land. One of the responses then in New South Wales does it early is to introduce a statutory form of condominium. And British Columbia follows the New South Wales template, which I think was introduced in 1961. 5 years later, in 1966, borrows the terminology, borrows the structure and form of the New South Wales legislation to create a Strata Titles Act. And here it is, 1966, the Strata Titles Act. And the Strata Titles Act allowed for the possibility of subdividing land into, or subdividing a building into individual freehold parcels. So land may be subdivided into strata lots with a deposit of a strata plan, and those strata lots act for all intents and purposes like other parcels of land. And here is the first, or one of the early condominium buildings. So it's 151st condominium development in Vancouver from 1974. Right? And here's the strata plan that subdivides this low-rise building. It's important to remember, and many of you know this, that strata or condominium not only subdivides towers, but also many forms, including townhouses, including low-rise apartments. So here's the plan that subdivides this into strata lots. And importantly, within a strata, and again, I'm speaking to many of you who know this already, but the strata plan creates a parcel of privately held land, strata lot 20. Each owner of a privately held parcel also holds a share of the common property. Here you can see the parking in the basement is common property. And then each owner has a voice in the condominium or strata corporation, the governing body. And so very quickly from 1966 until now, condominium really takes over and becomes, or is rapidly becoming, the dominant form of residential land ownership in the city. So it produces landscapes like this. I don't know what the figures are for Sydney, but in Vancouver now, 1/3 of residents in the metropolitan region live within strata property. 1/3 of people, either as owners or as tenants, live within condominium. Oh, I'm sorry, I'm going the wrong direction. So 1/3 of residents in Vancouver. And Vancouver is an outlier in Canada. So Toronto is next. 1/4 of residents within Toronto live either as owners or tenants within condominium. You can see in British Columbia, it's approximately 1/4 of the population. In Canada, about 15% of the population. This is a marker of an extraordinarily successful legal innovation. The condominium, only about 60 years old, now houses 1/3 of the people within Vancouver. So Vancouver is an outlier within Canada, also in North America, and to some extent globally, but it's representative of a trend around the world towards the condominium form. So again, to come back to my claim about that interplay between property and the built form, I think in order to understand what the city of Vancouver has become, it's crucial that we pay attention to a condominium or strata property form. Okay, now let's turn next to the airspace parcels. The practice of subdividing a parcel of land into volumetric spaces defined in 3 dimensions that might or might not include a portion of the surface of the earth began in New York, and it began over top of railways. And here we are right in the heart of Manhattan with Grand Central Station there and the railway company covering over its rail yards, right? So for Park Avenue as the street over top, and then those spaces either side are going to fill up with office towers, with hotel towers. The railways in the 1910s and early 1920s sold long-term leasehold to residential, to airspace parcels. So the railway would continue to hold the freehold in its land, but would sell a 99-year lease to a space defined in 3 dimensions on which an office building or a hotel or other complex would be built. In 1927, the state of Illinois passed the first Airspace Titles Act that allowed for the possibility of creating a freehold interest above an existing freehold interest. So one of the early buildings that used this, jumping between pointer and laptop, is the Merchandise Mart building in the 1930s when it was built, the largest building in the world. It's built over top of tracks, and here you can see the tracks coming in underneath, right? So the Chicago and Northwestern Railway sold an airspace parcel, or what the state of Illinois called an air lot, to the Merchandise Mart building to build this structure above the tracks. And here is that air lot. So this cube here is the space in which the Merchandise Mart building is built. These pillars are the pillars that you see in the image. All right, going through. So the part of the air lot is the pillars that support the building, and then the columns underneath are the foundations. This is all part of the air lot that the Merchandise Mart building held in freehold, and the Chicago and Northwestern Railway held the freehold interest in its rail lands. In 1937, New Jersey generalizes this, the first jurisdiction in North America to generalize the possibility of creating air lots, not just above railways, but anywhere. And British Columbia follows, and is the first province in Canada to do something similar. In 1971, it introduces the Airspace Titles Act. Oh, dear story. And the Airspace Titles Act, right, allows for the creation of airspace parcels. Now, an airspace parcel is just a 3-dimensional parcel of space. And that 3-dimensional parcel of space, right, is created when the holder of the freeholder, the fee simple interest, deposits an airspace plan. And that airspace plan then creates one or more airspace parcels. And those airspace parcels right, as with a strata lot, right, are to be dealt with as any other parcel or interest in land. Now, why in 1971 did British Columbia introduce the Airspace Titles Act? Well, it was in an effort to facilitate the building of this complex. This was known as Project 200 in the 1960s. It was anticipated it was going to cost $200 million to build. It's a mixed residential, commercial, retail, hotel complex on Vancouver's waterfront. And you can see at the bottom here, the railway tracks coming in and the railway tracks coming out the top. The Airspace Titles Act was introduced to allow for the possibility that this development could be built within an airspace parcel that was held in freehold. And again, think back the importance of the freehold or an interest in land as a mechanism for securing finance. The lender is going to want the largest property interest that it can hold to secure a loan. This would allow for the developer to use the freehold interests in the airspace parcels above the tracks to develop the land. The project never happened, or at least one tower was built. It relied on connections to a freeway system that was mostly never built. The federal and provincial funding for the freeway collapsed, and so the development didn't happen. But the enduring legacy of Project 200 is the Airspace Titles Act, to allow for the possibility of subdividing land into volumes. And the very first airspace parcel that is sold in British Columbia is this one. Now, a much more modest airspace parcel than what was contemplated for Project 200. It involved air above a laneway. So here's Granville Street, here's Seymour Street. There's a laneway in between. A theater company had space for a theater off Seymour Street. The problem with Seymour Street was that it was a low pedestrian. Pedestrians didn't use Seymour. It was light industry and manufacturing or warehouses. Granville Street was the entertainment district. And so the theater company acquired a lot on Granville Street, had an escalator that came up, so you had frontage on Granville Street, and then needed a catwalk or an overpass to its theaters in the back. And so the city of Vancouver sold it, and here's the airspace parcel, right? Sold it in an airspace parcel in order that it could build an overpass over the lane. Now, I have a project to track from this very first airspace plan in 1975, the use of airspace parcels in Vancouver. And the first 6 are numbered airspace parcel 1, 2, 3, 4, 5, 6. Right? They're really simple. And then the numbering changes and they're impossible to track, or at least much more difficult to track. So I've got as far as 6, which isn't very far. But I thought when I began that the early use would be like this, right? Just sort of cubes of space. But actually what I discovered is that the 6th parcel is much more involved and much more complex. And here's the 6th parcel. Now, somewhat harder to read or understand than that simple cube above the lane. But you start with a parcel of land, and then what the developer has done is create an airspace parcel, which is this shape here. And underneath it, you can see the hashed lines. It's another airspace parcel. So 2 airspace parcels, one on top of another. This was for a mixed use residential and commercial development on False Creek. So this is airspace parcel 1. And now here's the airspace parcel underneath it, right? So airspace parcel 1, airspace parcel 2 is here, and there it is. Airspace parcel 1 and airspace parcel 2. And this is the building that emerges. I'm sorry, wrong. This is the building that emerges. So here's airspace parcel 2 with the commercial shops, and then here's airspace parcel 1 with the residential parcels above. So this is early on in 1976. We're all beginning to get a complex set of volumetric structures, subdividing a mixed-use development commercial and residential. And let me show you a more modern example, and something that's become increasingly common in mixed use development. So here's a tower on Vancouver's waterfront. It happens to be on the same site where Project 200 was going to be built. And you can see by looking at the built form, there's different things happening. So the lower 20 stories approximately are professional offices, commercial offices, lawyers, doctors' offices, physiotherapists, accountants. And then when the windows get bigger and their balconies, this is residential. So you have a mixed use, commercial and residential. And those uses are contained within separate airspace parcels. Now here's the airspace parcel that defines the residential. Right? So you have a podium, a tower, right, a shaft for the elevator and utilities through the commercial space for the residential space above. This is airspace parcel 1, and then the area around it occupied by the commercial offices is airspace parcel 2. And here's the a side-on view that's somewhat simpler to see. This is really interesting, right? It's like a popsicle. Yeah, popsicles. Yeah. Well, you probably invented them, right? Popsicle on a podium. And so the podium is parking. Here you've got 2 stories of the street level lobby entranceway. On this, sticking off to the side, right, is the fitness center and meeting rooms, then the shaft for elevator, and then the airspace parcel. So the airspace parcel, right, contains the space within which the residential which contains the residences.
Sorry.
Yes.
So the bottom half is actually part of the same airspace parcel?
Yes, this is all one airspace parcel. Everything here is one airspace parcel, right? So it's not just that cube anymore, right? It's this really complex physical form. And then the remainder here and right in all this, right? It doesn't float like this on the podium and the stick. It's this, there's the offices occupy.
And it's around.
And so that's right. Yeah, that's right. And surround. So this the stick goes right through the middle of the office spaces. Now, what you can do with these airspace parcels is combine condominium subdivision with airspace parcel subdivision. And this was always contemplated. So remember, the Condominium or our Strata Titles Act was introduced in 1966. The Airspace Titles Act in 1971. It was imagined from the beginning that the two would be used in tandem. And so here is now the current version of our Land Titles Act, right, which provide that the holder of the fee simple interest can create an airspace parcel, and then that airspace parcel may be subdivided in accordance with the Strata Property Act. So you start with a single parcel, and the single parcel always has volume. Land has always had volume. But now we've subdivided it, first using airspace parcels, and then we've subdivided further the airspace parcels using the condominium form. So to come back to the cross section, right, here's airspace parcel 1, and now here's airspace parcel 1 subdivided with strata lots or with condominium lots. And this is an increasingly common and an incredibly complex set of relationships. So the person who's acquiring this 2-bedroom strata lot is buying that strata lot within the framework of the Strata Corporation and all of the bylaws and finances and decision-making and rules, but then is also subject to a complex set of easements and covenants in what are known as airspace parcel agreements that define the relationship between airspace parcels. So this is airspace parcel 1, but it can't exist without the remainder airspace parcel. And so there's a set of access agreements, support agreements, who's going to ensure what, who's going to cover what cost, dispute resolution. All of those are contained in airspace parcel agreements. And the owner of the strata lot, right, as a member of the strata corporation, which becomes a party to these airspace parcel agreements, is subject to hundreds of pages of dense legal text defining the relationship between airspace parcels. And it's something that I've worked with a little bit in this piece of mind that you see at the bottom, volumetric subdivision and the architecture of property. And part it's an engagement with property theorists who are saying the right to exclude is the core of property. And I'm saying, well, the right to exclude is important, but the right to exclude is nested within this dense set of relationships defined first with condominium and then in these airspace parcel agreements that are at least as important, or at least need to be understood as part of the property interest. Now, this is also, I've focused on Vancouver. Some of you will know that this is also an Australian story. So in New South Wales, right, the form is not airspace parcel, but stratum. Right? And then this stratum can be subdivided into strata units. And this is the infamous Italian form, which I'm sure many of you know better than I do, which Michael Tace, when he was here at the school, wrote about, and which Kathy Sherry has written extensively about. But it's the same basic legal architecture of volumetric subdivision within volumetric subdivision. So condominium subdivision within airspace or stratum subdivision, producing extraordinary complexity that makes it very difficult for a purchaser to know exactly what it is they're acquiring. And as Kathy says here at the bottom, an unholy mixing of contract and property. You think you're buying a property form, and you're buying your freehold interest in this unit. But attached to that and running with it are all of these complex contractual terms that make it very difficult to understand what it is once acquired. Okay, so let's come back to this building. No, sorry, Ron, but let's come back to this building. Right, so a much simpler subdivision, and right here it is again. Here's the airspace parcel. Now, this airspace parcel was, like that tower I just showed you, subdivided into strata lots. So here's the deposit of the strata plan, right, that carves out the separate strata lots. This is for airspace parcel 1, so the residential portion. And this is what it looks like in cross section. And again, right, this isn't the built form, right? The built form has the commercial underneath it supporting it. But here are the strata lots. So airspace parcel subdivided into the strata lots. Now the difference at this one is that the strata lots are leasehold strata lots. So what are these? These are prepaid 99-year, or in this case, prepaid 60-year leases. So the person acquiring the strata lot is not acquiring the freehold, which is more common, but are acquiring a leasehold interest, or whatever's left of that 60 years. And this was made possible in 1974 when British Columbia introduced the second generation of its strata property legislation. And when it did so, it provided an elaborate set of provisions around how to create leasehold interests. And so with the deposit of a leasehold strata plan, a certain number of entities, right, the provincial crown, the federal crown, municipality, regional district, or other public authority may use a leasehold strata plan to subdivide a building into leasehold strata lots. So ordinary developers couldn't, only public entities or public authorities. Why in 1974 did we get this? Again, so thinking back, this interplay between the city and property law. Well, in 1974, the city had recently acquired through a land swap former industrial land on Falls Creek. Here it is, this empty land here, and a new left-leaning city government wanted to build a mixed income community. And to build that mixed income community, it would have various types of tenure. There would be subsidized rental, there would be market rental, there would be subsidized co-op, and there would be condominium units. But the city didn't want to sell the freehold interest. It wanted to retain the reversionary interest, the right to recover the land at the end of a lease. And so it petitioned the provincial government to introduce the possibility of leasehold strata. And it's a very conscious attempt by the city to create a socially, economically mixed community using land tenure and so that the possibility of being an owner, not of a freehold, but of a leasehold, would attract a higher bracket income level. It would also help finance the building of you could prepay for the leasehold, and then it could help finance the building of the rest of it. And this is the neighborhood this is the neighborhood that emerges. So this mix of tenures, and the building that's subdivided using the leasehold is this one right here. Now, let's just stick with the leasehold for a few minutes. The possibility of using the leasehold gradually expands. I remember initially it was just the federal crown, the provincial crown, municipalities, and other public authorities. Well, now Government of British Columbia, Government of Canada, municipality, regional districts, the Nisga'a, so First Nation up in the northwest corner of the province, signed a treaty in the late 90s with British Columbia and Canada. Another treaty First Nation, so another First Nation that's party to a treaty, or another public authority. So who counts or what counts as a public authority that can use the leasehold strata interest? Well, here's the list in the regulations. A public authority means university. So UBC has used the leasehold extensively to develop part of its land endowment to build Westbrook Village. So it's selling, what's it selling? Selling long-term leasehold interest. Why? Because, well, it wants to retain the reversionary interest to recover the land at the end of the lease. A few other bodies, provincial housing corporation, school boards, and then Musqueam Block F Land Limited. Okay, so a company now has the capacity, but right, Musqueam, what's this a reference to? So in 2008, as part of a reconciliation agreement, the province transferred to the Musqueam what's known as Block F, this parcel of land in red, right adjacent to the University of British Columbia. And the Musqueam are using Block F as an income generating development site. But the Musqueam, having reacquired a portion of the territory, have no interest in selling the freehold interest. But they wish to use it as an income generating site. And so what they petitioned the province to do is to allow them to sell, as the city can, as the university can, long-term leasehold interests. And so come back here, but it's a Musqueam Block F Land Limited. So the Musqueam set up a company that owns Block F, and that company can sell long-term leasehold. And here's a sketch of the development. The first the third of it, this end has already been built, and the Musqueam are selling. So it's about 10 acres, maybe a little bit more. It's about 1,200 residential units, some of which are rental, most of which are leasehold. Okay, let's come back to the list. MST Fairmont Land Holdings Limited. What's that? MST is a development corporation created by the Musqueam, Squamish, and Tsleil-Waututh, so 3 First Nations, to use as their vehicle for land development. And the Musqueam, Squamish, and Tsleil-Waututh, through the development corporation, have gradually been acquiring surplus parcels of Crown land. And one of which they've acquired is this one. It's called the Heatherlands. It's the former Royal Canadian Mounted Police, RCMP base. You can see where it is, not far from downtown Vancouver. It's about 20 acres of land. So it's held by the MST Development Corporation. And the MST Development Corporation, MST Fairmont Land Holdings, has the power to use the leasehold to subdivide. And this is what's the latest iteration of what is emerging there. So this is about 20 acres, about 2,500 units of long-term leasehold strata development. And here's a artist's rendition of it. And then one more, and let's wrap things up soon. But this numbered company. So what's that? Numbered Company BC Limited. Well, that numbered company owns a parcel of land in Burnaby. Burnaby is an adjacent city to Vancouver, part of Metro Vancouver. And that numbered company that owns the parcel of land is in turn controlled by Willingdon AQMIB TWN General Partner Limited. So numbered company owns the land. This is the controlling company. And the project that's to be built on this 40-acre parcel with about 5,000 units of housing is Kawasam Village. Who are the players in Willingdon? Well, there's three, right? Musqueam Indian Band, the Musqueam, Tsleil-Waututh Nation, and then Aquilini Development, so one of the large developers in Vancouver. So the three of them have combined, again, to acquire a surplus parcel of Crown land. This was a liquor distribution branch, and to build this, or at least this is what's proposed. So again, about 40 acres, about 5,000 units of housing. And again, so the leasehold here is a really important part of these developments, because the First Nations that are now acting as some of the major land developers in the city have no intention of doing what most developers have done, which is to buy, to build, to sell, and to leave. Right, so they're reacquiring their traditional territories, right? In some cases, having to purchase it back, but reacquiring it. Wishing to use those sites as sites for economic development, as income generating, but wanting to retain the freehold as a way of retaining and building their territorial footprint. And so now have the opportunity to use the leasehold. And so the leasehold is becoming an increasingly prominent part in pockets of land development, the university in particular, but now, and the City First University, and now First Nations. So let me just come back and wrap up and with architectures of property, and just again to think through and to explore the way in which the city can be understood as a site of property law, a space in which it is participating in creating the legal forms. The city was very active in advocating for the leasehold in the strata, in the airspace parcel possibility, and in the creation of condominium, and then how those legal forms are themselves playing a role in transforming the city. So again, as a legal scholar coming at this, and I know I'm speaking to many of you with disciplinary expertise elsewhere, if the contribution that I have is anything, it's to think through the way in which these legal forms are both being created by and creating the city. Very much look forward to questions. Thank you all for your attention. Laura.
Thanks. It's really interesting and great to see so many sort of live examples of these things as well. I was just interested, you mentioned what they call airspace parcel agreements.
Yes.
That then bind, if you've got a strata plan, that then bind the owners of the strata lots as a result of being part of the strata corporation. Is there any legislative overlay of what those arrangements look like? Because one of the conversations we've been having here is that, you know, those overarching agreements that we have with Stratum don't have the same sort of legal protections in terms of the, requirements under the legislation. So I was just interested if it was the same issue that sort of those agreements can be anything that the lawyers for the developers dream up, and then the owners are bound by them once they buy in.
Yeah, okay, terrific. So yes, in a nutshell, is the answer. So what happens? How does this happen? So developer holds the parcel of land, right? Subdivides it using airspace parcels. So creates two airspace parcels. And then while still the owner of both airspace parcels, creates an airspace parcel agreement that defines the relationship between the airspace parcels. So then the developer builds the structure. And then while still the owner of all of the units in the Strata Corporation, then binds the Strata Corporation to the airspace parcel. So now the Strata Corporation, as the owner of airspace parcel 1, becomes a party to the airspace parcel agreement. And so that's the mechanism. And then each individual purchaser that buys into the Strata Corporation with the purchase of a Strata lot becomes a member of the Strata Corporation. And right, and as many of you know, there's no limited liability in a Strata Corporation, right? Each owner is responsible solely and collectively for all of the obligations, debts, assets of the Strata Corporation. So each owner is becoming a party to complex set of easements and covenants, right? A contract that the developer has set up in the first instance. And to come to your question, is there any statutory framework for that? In British Columbia, none. So I know there's a little bit in Australia, right? Strata management schemes and strata building schemes that provide just sort of a basic outline of the structure of these agreements. In British Columbia, there's none, so it's entirely up to the developer what those agreements contain. And this is the principal weakness in that what one's doing is buying a freehold interest in a strata lot. You think, okay, I'm buying a property interest. I know what a freehold interest is, and I know what a freehold interest is in a strata because they're standard. The governing structure is set out in the legislation. The basic formula for the allocation of costs are standard and set out. I know what I'm acquiring within a strata corporation, but I've got no idea unless I can understand the detail of the 200, 300, 400, 500 page contract that defines relationships between airspace. So I've got no idea what I'm binding myself to in terms of the relationship between airspace parcels. So I think if there's a policy recommendation in this work, it's that when it comes to property interest, standardization is really important, right? Because property interest, we allow individuals to contract with each other and then bind the parties to the contract, and you can, there's constraints, but we allow for all sorts of fine-grained detail, and right, and parties to the contracts are then bound by the contracts that they bound themselves to. But with property interests, property will bind whomever becomes the owner, whether or not they bound themselves by contract, and that's where the standardization is crucial. So it's a long way of answering your question to say, I think we need, if we're going to allow this to continue, we need some standardization, some off-the-rack template. Right? Carol Rose's great answer to the question she poses: what can governments do for property? They can provide off-the-rack templates, right? They can standardize it so that people know what it is they're acquiring.
I've got a question, Doug, but I think there's somebody for me online.
Okay.
Yes, correct.
Can you hear me okay?
Yep.
Yeah.
Thanks for that. That was an excellent presentation, and the core of it made a lot of sense. So I have a slightly tangential question. I was curious about the First Nations organizations that were set up to do this sort of property development, and your experience in Canada about how they're going in terms of governance and wealth generation for their members. Just because obviously this is something that's also analogous and something we're thinking about in Australia, as sort of, how to set up relations well with First Nations people.
Yeah, great. So thanks for the question. And it's not something I've studied in depth, but in part, the creation of these corporate forms to hold interest in land was a function of the fact that that by law, First Nations were not able to hold interest in land themselves, or at least could not hold a freehold interest. The First Nation could not, until just last year in British Columbia, hold a registered freehold interest. That changed, so now the First Nation can itself, as a legal entity, hold the freehold interest in a parcel of land, just like you or I or a corporate entity can. But until that changed, the only option was to create a corporation in which the First Nation was the owner and the directing authority to do these land developments. Now, to the extent to which they've been successful, so both the Musqueam, Squamish, or all three of Musqueam, Squamish, and Tsleil-Waututh are very sophisticated players in land development. So they have practice at this and are good at it. What the financial returns are, I don't know. So I haven't done that. I haven't done that work. But the corporate form was in part, at least at one level, necessary to do these. And at another level, it protects the First Nation, right? So as a corporation, there's there's limited liability. So the First Nations are to some degree protected by the corporate form as well as having until recently been required to use it.
Thanks, Doug. That was really fascinating. Now, it never ceases to amaze me how complicated we've made our built environments. I've got two questions, and I think there's just observations from, we have done that comparative work with Vancouver as well. So there's things that sort of stand out, which are really fascinating. The first is I'd like to hear a little bit more about sort of strata leasehold. And is that, I presume that's selling a product for a particular time period. So what is that time period? Is it like 125 years? Is it 999 years? What's the thinking there? And tied to that is, how does that relate also to, another outsider observation is that build to rent, or whatever you call it there, has been much more dominant in terms of a strategy for densification. And so that sort of build to rent, where you assume that there's a single owner remains in control of the building. How does that relate to that sort of leasehold for sale market and that route?
Yeah. So there is a standard term on these prepaid leases, and it's 99 years.
Just 99
It's 99. Yeah, it's 99 years. But it doesn't have to be 99 years. And the first ones that were used by the city were only 60 years, and that was in the late 1970s. So they come up in the 2030s, and so the really important question is what happens at the end of the lease. And so leases are contracts that create property interests, right? But so what happens at the end of the lease? We got to look at the detail of the contracts, because our legislation is inadequate for the endpoint of the lease. The legislation says that the landlord has to buy out the leasehold tenant as if the leasehold interest never ended, which is basically saying as if the leasehold interest were a freehold interest, because the feature of a leasehold interest is it has an end date. The feature of freehold interest is that it has no end date, right? So that's or at least has the potential to last forever. So we've got to change, and I'm part of a working group thinking through some recommendations around the leasehold. But the standard is 99 years. Which seems long at the outset, but very quickly diminishes to nothing. A lease is a wasting asset, right? It disappears. So that was the first question. The second question
was more about how this sits with
rental.
Rent to buy, which
so
no, not rent to buy. Sorry, build to rent.
Yeah, institutional landlord buildings. From the early 1970s until about 10 years ago, there was almost no dedicated rental being built. And that was because of a number of changes to the tax regime in Canada. Landlords could no longer write off losses in residential tenancies against other profits, which had been a considerable incentive to build rental tenancies. There's also the capital gain of your home is not taxable. So there's sort of a tax incentive to be an owner and not a renter. So for a bunch of tax reasons, the construction of dedicated rental stopped, and also for a bunch of other reasons, including the financing of buildings. So in British Columbia, a developer can pre-sell a building, and if you pre-sell, then you have the money that you need to build before you build, and so you use the pre-sale revenue to build, and then so it was for a whole set of reasons it was more profitable to build, and so there was almost no building of dedicated rental until about 10 years ago, when the city said, hang on a second, this is a huge hole in our housing, we need more dedicated rental. And so started creating incentives by giving the developers extra density in order, right? So you can have effectively another 5 floors if you build this as a dedicated rental rather than as a strata. But interestingly, so through the 70s, 80s, 90s, early 2000s, the increase in our rental stock came through the strata properties. Many of them were built to rent. But it's less secure rental because a mom and pop investor owner can use their occupation of the property as a basis for an eviction. So an institutional landlord can't, right? An institutional landlord is never going to become the occupant. But if a small scale investor says, well, actually, I need that building to live in, or for a close family member to live in, that can be the basis for eviction. So the strata property was our large part of our rental housing stock, but less secure. Hazel.
I was interested that the leasehold strata legislation had a list of allowable organisations that could use the model. Why is that, and why was it not just introduced that anyone could do it?
Let's just go to that list. So this is in the Act, right? And then the public authority, and then the regulations, a longer list. And so, so why not allow a private entity to do this? Why only allow, in effect, what are public entities, public including First Nations, to do this? And I guess the question is, so what would be the basis? What does a leasehold interest provide? Well, it allows for the freeholder to reacquire possession at the end. So why would it be important to give a private developer that reversionary interest, the capacity to reacquire possession at the end of the lease? I think the justification for doing so for public bodies is pretty clear, right? That this is part of sort of, right? That reversionary interest is part of, is a public asset. And so you can sell a chunk of it, maybe years of time in the land, but at the end of that, it will come back to the public or to another public body like a university. And it's a particularly powerful tool for a First Nation that wants to develop and generate income, but isn't interested in it's using their freehold as a way of recovering some degree of sovereignty in territory. It's this interesting blurring of property to reestablish a sovereign presence in the territory. And so that reversionary interest and the status of the landlord leaseholder allows for that. So I guess the question would be, why should we allow private entities that reversionary interest? And what would be the danger if we did? Well, rate the private accumulation of land. So I think what's the situation in New South Wales? Are there leasehold strata?
There are
I should know
leasehold
that.
strata. The only ones I know of are on public land, like around Darling Harbour, there's leasehold strata, but on government land. I don't know if there's any private ones.
The other side is taking a ground lease out on private properties. So you might build a building, like a McDonald's, for example. They might not own the property. You might retain ownership of the property, but they will build their restaurant on top and pay you a ground lease.
Yeah.
So that's sort of the reverse way of looking at it.
The other way of looking at it.
I had a follow-up question to that. One of the players with, I think, the First Nations group was a private company in that list as well.
Yes,
They can partner.
yes,
You know,
that's
do
right.
that.
That's right. Right, and so
The
that,
second question was, can the list be extended if necessary? But would it require changing in the legislation?
or the regulations, right? So this
Yeah,
is in the regulations, so it requires an order in council, but not a vote in the legislature. And so these last ones have been added since 2015 or 2016. I think the Musqueam Block F was added
That's
in
possible.
2016, and this one was just added last year.
Yeah.
These two were just added last year. So the list is gradually growing, and it's growing piecemeal.
It does include private companies.
And you're right, and this last one does include, so in all these others, the sole owner is First Nation,
Or government.
or with some of these, it's partnered with Canada Lands Corporation, so a crown corporation. But with this one, the Aquilini Group holds a third interest. And so this one's different than the others.
Yeah.
Yeah, and it's happening piecemeal. And so again, it's a question of should the list continue to extend like this? Should we go to a situation where First Nations are just added generally, like not just treaty First Nations, but all First?
Or is private industry going to get more involved with partnerships?
Or is private? Yes, that's right. That's right. Or right to Hazel's question, should it just be opened up generally? Although my own view is that I would be very cautious, right? So I think that reversionary interest is justifiable when the body is a public one, right, or a First Nation. I'm much less convinced that it's justifiable if the body is a private entity.
All right, now a question in the chat box from one of the online audience. Ed Wednesday asked, here in Canberra, we have a 99-year leasehold system, but it has been severely pared back in its effectiveness, principally because of the application of a betterment change or change of use charge, which the development industry has vociferously objected to, and residential leases are automatically renewed once they reach their 99-year term for another 99 years without a premium payment. But we still have it in name. The development industry continues to object to it and want it reverted to freehold. I'm interested to hear whether the development industry in Vancouver has the same kind of aversion to leasehold. So
There's a copy of it behind you.
So thanks, Ed. And so these, what sounds like an evergreen 99-year, at least right, an ever repeating 99 years.
Lease in perpetuity, they call it.
Yeah. And so a lease in perpetuity is an effective freehold. But with added complications. And so the question is why? Why would you do such, like, what's the policy basis for doing such a thing? And I don't know. And in terms of the I don't know. I haven't heard from developers that they're keen to use the long-term prepaid leasehold. There isn't a groundswell, at least not that I'm aware of developer interest in having this leasehold strata be available more generally. But maybe I just don't have my ear close enough to the ground on that one.
Hi, Peter Hunt. Two questions, relatively simple, I hope.
Probably not.
Going back to the Project 200 air rights proposal,
Yes.
when the subsequent development occurred, did it remain within the original air rights parcel, or did they seek to build outside the original grant?
So with this development, so it never happened except for one tower.
But the strata was created, wasn't it?
No, it wasn't. It never was in this one. There was one tower that looks approximately like this one in the middle, although not quite. And it was the legal arrangement was made for it before 1971 and Airspace Titles Act. And so in this one, the developer of the tower acquired the freehold and then transferred a long-term leasehold interest to the railway. So in fact, there's no airspace parcel. There's just a lease to a portion of the freehold. So the first one, right? The first one is this much less complex walkway.
And then my subsequent question is, with the popsicle diagram with the two airspace stratas, it seems to be ridiculously complicated. And did they think about using a stratum process as we have in Australia? Because I think that would have alleviated some of the problems, probably create other complications, but I can't see the justification of separating residential out from commercial when you can do it in a stratum type of situation.
Yeah. So we don't have the stratum option. Although the stratum option doesn't provide much in the way of direction, like it's some, right? You have to have a building management committee and there's some.
But it gives you that separation between the two, I suppose. It can be all on the one stratum lot, effectively.
Yeah. So your first observation, this is enormously complicated, and this is a relatively simple one. I mean, that Italian form was 5 stratum, and there's 5 and 7 where there's a development in Burnaby that litigation that went up to the Supreme Court of Canada. There were 7 airspace parcels, so a hotel, a residential, an office tower, professional offices, retail, a police station, a library, and a parkade. But each of those are separate airspace parcels and then subject to these complex agreements. So enormously complex. What there is in British Columbia is the possibility of creating sections. So what you could do is, instead of separate airspace parcels, you could have 2 sections. And the sections are, in effect, strata corporations within strata corporations.
So that could be the residential and the commercial, for example.
As separate sections, which in effect are as mini strata corporations under an umbrella strata corporation. Developers have abandoned that almost entirely, in part because they're not wanting the constraints of the condominium form. So the condominium form describes how you can allocate expenses, and so it acts as a significant constraint on what you can do. So the section option would in some ways help solve some of the complexity by creating a standardized template in which to do this, but almost entirely now we've gone to airspace parcels.
And thanks everyone for joining. Just a reminder that our next seminar will be held in 2 weeks on June 19th at 1:30 to 2:30, not 4 o'clock anymore. And our next seminar will be online only, and we'll hear from Professor Hal Pawson, who presents National Housing Policy and Supply in the 2020s, comparing Australian and Canadian approach. We look forward to seeing you then, and I wish everyone a great afternoon. Thank you.